Hi, everybody. Thanks for tuning in virtually. So my name is Momina, and I am your session coordinator for the night. And today we are joined by Michael Johnston. So Michael, I'm just going to turn it over to you to do a quick introduction of yourself, anything you want to say about your job as a legal professional.
Thank you very much, Momina. As indicated, my name is Michael Johnston. I am a barrister at law, or as many people often refer to us. I'm a trial lawyer, or I'm a lawyer, but in particular, I'm a lawyer who goes to court and argues cases. Particularly, I represent your brothers, your sisters, mothers, fathers, cousins, anybody in the community who might get accused of having committed a crime. I'm one of the people that stands by their sides and assists them with respect to allegations and helping them protect their constitutional rights, rights like to be presumed innocent, to insist that there is sufficiency of evidence behind any allegation, that is, that the evidence could achieve what we call proof beyond a reasonable doubt. So in short, that is what I do. I am a barrister at law or a criminal defense lawyer.
Thank you so much, Michael. And the thing about our viewers is a lot of them are really interested in criminal defense. So I'm pretty sure this would be very interesting to our generation. Sorry, just turn off my phone. So the first question I have for you, Michael, is we usually start these sessions just getting a bit of background on your education. So do you mind telling me what university you went to, what types of courses you studied in your undergrad, and what that experience was like for you?
Sure. But let me back up for just a second, because you started by asking me something that is interesting. You said you like to talk about education, but then you just focused on my schooling. Now, there is a very famous writer from the 19th century by the name of Mark Twain, or Samuel Clemens, and one of his, or many of his sayings appeal to me, but particularly, he said, don't ever let school get in the way of your education. So my education, in some ways, for whatever it's worth, didn't just start when I went to university to study philosophy, for example, or when I went to law school. You know, you supplement your education at all times by history, reading books, etc. But with that now being qualified, you're asking me particularly about what I studied. In terms of my education, I went to a high school here in Ottawa. It's called Colonel By. And I graduated from Colonel By, and I went to the University of Laurier, where I played football for a year and majored in political science. And then I transferred from Laurier to Queen's University, where for the next 4 years I played football and I studied political science, and then I transferred from political science into a philosophy degree. So I ended up graduating at the end of my football career, so to speak, with a honors in philosophy from Queen's University. Following that, I applied to law school, and I went to law school.
So what prompted you to switch to philosophy from political science, which was your original plan?
A very fair question. I wish that I had a very principled reason, but in truth, when I was in high school, I wasn't particularly wild about math. I always found math to be somewhat of a trying subject. So after I achieved my grade 10, which I believe at the time was the mandatory kind of requirements to graduate from high school, I wasn't going to take any optional or elective mathematics courses. Once I was enrolled in political science, which in truth was and remains a very fascinating subject area for me, one of the mandatory courses for graduating from political science was statistics. So not interested in numbers since high school, I thought, well, I kind of tried to avoid that back then. I'll try to avoid it right now when I can study, because political science is in some ways political philosophy. So I can just study the same things, but maybe I don't have to take this statistics course. And I mean, the way that life sometimes works out, interestingly, I loved philosophy, but one of the mandatory courses in philosophy is symbolic logic. And symbolic logic ends up being mathematics. It's actually first order predicate calculus, but rather than using numbers, they use symbols. So that's how that banged out.
I'm actually taking that statistics course you're speaking of next year in my second year. So good luck to me. I won't switch to philosophy though. Michael, could you do me a favor? You just seem to be frozen on my screen for a second. Do you mind refreshing your page?
Sure, no trouble. Did that work?
It did not. I don't really know what the issue is. It's okay. I can hear you perfectly, so that's all that really matters. Thanks for talking about your education in terms of your undergrad and your supplemental education, as coined by Mark Twain, aka Samuel Clemens. I also wanted to talk about law school with you, which specific law school you went to, what type of courses you did there, and what your overall experience was like in law school.
Okay, sure. So when I was in my undergraduate degree, I very much still had the notion that at some point in time I would go to law school, but it seemed a distant prospect at the time because I was so dedicated to becoming a professional football player, and I was playing football, and lo and behold, lots of knee injuries ended any dreams I had of athletic delusions of grandeur. And so I had to think about law school, and I had done okay in my undergrad, but my concentration and my efforts had really been on football. So having applied to law school, I had to apply to certain places, appreciating that perhaps I didn't have the highest marks, which for me was okay, because at the end of the day, the practice of law requires a license. It's like a license to drive a car. You know, it doesn't really matter if you go to X place or Y place. What matters is that you get the license. So I looked at it from a pragmatic perspective, and I applied to a couple of schools in Ontario, but I also was very interested in the University of Saskatchewan. And interestingly, I didn't get into any schools in Ontario, and I was given an offer to attend Saskatchewan. I had never been to Saskatchewan, to be fully truthful with you. The first time I ever stepped foot in the province was when I took a flight to get there for my first week of school. But lo and behold, I was super fortunate, because for me it was the right place. So that I know that that's now been a bit of a longer answer, but that kind of explains, I guess, where I went to law school. And you had kind of a compound question, if you don't mind my asking you to repeat another component of it. You wanted to know not only about the law school, but then also my law school experience. Is that correct?
Yeah.
What in particular do you want me to talk about in terms of my law school experience, just so that it better lends itself to our audience and perhaps provides some insight?
Well, first of all, thank you for long answers, because myself and our viewers, we really like detailed answers. And for law school experience, I'm more so asking about any courses that may have stood out to you, any clubs that you joined that you thought really helped you in terms of your practice.
Well, my law school experience was exactly what I intended to make of it in some ways. That makes any sense. Law school is a very difficult and a very demanding couple of years, but you're an adult by the time you get to law school. You're usually well into your 20s, and it's by that point in time up to you to determine how much or how little effort you want to put into school, and also appreciate the effort that you put into school isn't just about getting grades no longer, or maybe being able to satisfy your parents so you can go out and play on the weekend. Here, for me, one of the important things that I took into law school was, in a very short period of time, I'm going to have the super and grave responsibility for protecting individuals who are accused of crimes. So I, rightly or wrongly, it was my approach, and as I said, rightly or wrongly, I approached the matter very seriously. I had an incredible football coach who once told me, if you want to be a professional at something, don't wait around until you get paid like a professional. Take your professional attitude and apply it. So I went to law school and applied what I thought was a professional attitude. If I'm going to be working 60 or 80 hours a week as a lawyer, I better get used to that now. So my law school experience was very much driven by that approach. I had the good fortune to have sufficient financial freedom, loans, etc., that I didn't have to worry about working, and I thought studying will be my full-time job. So I studied as much as I possibly could. I can't say that I had the most, I'd been an undergrad and I'd played football, which was itself a different experience, but this was very, for me, 3 years of very hard, intensive study, most of the time just in my room. But for me, that was okay. It very much is what I signed up for. In terms of the courses that I took that really stood out for me, the course that has always appealed the most to me and continues to be of the greatest interest is constitutional law, because there's no, for me, more interesting subject matter than the law about the laws. What can the government do? Well, here are all the rules about what the government can do. Because ultimately, my freedom is somewhat contingent on what the government takes from us, right? Like, you're free, you're born free, and the government only has the power that we've given to them. And it creates this interesting tension as between individuals and governments. That's kind of the balance in which we engage in any democracy. So I loved learning all about, well, the government can do this, the federal government can do this, the provincial government can do this. You as people have these protected spheres, you know, the right to not, have your person or your home searched unreasonably, generally without a warrant, all these preconditions that protect what we've come to understand as our freedom. So for me, that was all found in constitutional law, but then it also started making even better sense in the context of penal law or criminal law. And I hate that term, criminal law, because it suggests the law is made for criminals. And even the term criminal defense lawyer is kind of a stupid term, because I don't defend criminals. I'm a person who assists individuals who are accused of crimes, but you got to prove that they're a criminal. That's a bit of an aside. So I loved constitutional law. I loved criminal procedure, because procedure is exactly that. The Constitution says that the government can write certain procedures, and so certain procedures have to be followed. And if they're not followed, then your freedom is being unreasonably infringed. I also liked, for example, the law of evidence, because ultimately cases are won or lost based on proof. So what can constitute proof and what can constitute inadmissible evidence? To me, these are all kind of really the meat and potatoes of what make up our liberty. And so I loved all of these subjects, and they very much are things that I thought about before I went to law school, that, maybe gets back to what I was saying previously about having an education that transcends your schooling. I have always been reading these types of things, and they kind of found their best expression through those subject matters. I can also advise, though, that I was interested in those subjects generally because at a very early age, I was interested in practicing law, particularly helping people as a result of an early exposure to a biography about Abraham Lincoln.
What was the biography about that compelled you towards law?
I'm sorry, it's just a bit muted, Momina. I believe you said something about, tell us about that biography, but as I said, it's just a little quiet.
Is it better now?
Same volume.
My mic.
That's much better.
Yeah, my mic can get a little fuzzy sometimes. Is it better now?
Yes, by all means.
Perfect. Yes, so the question was, can you tell me about the biography about Abraham Lincoln that compelled you towards law? Like, what was it specifically?
Just 1 second. So I was in grade 3 and I did this book report. You can see it right now. Like, that's literally the cover from my book report. I drew it in crayon, and it was called The Great Emancipator by Augustus Stevenson. There's a little bibliographical information. And so I believe, if my memory serves correctly, I acquired the book when I was on a little family vacation with my mother and father and two brothers, and we might have been in Jamestown, Virginia, and picked it up at a gift shop. And it was just because we were on this type of a trip where you drive massive amounts of hours. We used to have a little Game Boy and a Walkman, if the listeners know what that is at all. And so this little book was also purchased for me just to kind of pass the time. And the book was not as detailed as an adult biography, let's say, but it told the story of Abraham Lincoln coming up as kind of a somewhat illiterate schoolboy and finding books in the bottom of barrels and teaching himself about the law and how he became a lawyer and an unsuccessful politician for a while, and then ultimately acquiring power as a politician and all the great work that he did. So he was somebody that was impressive to me. I always was inspired by his actions, like the Emancipation Proclamation, somebody who had helped free the slaves. It seems, I'm not quite sure. I was impressed by it. I had also, my mother is somebody who had exposed me to a whole host of great kind of ideas. I at an early age was exposed to, let's say Martin Luther King Jr.'s "I Have a Dream" speech. And I can remember reading these things when I was in grade 5 and 6 and being inspired by them. So I know you were asking me about the biography. I can't tell you too much about it other than those broad brushstrokes, but it certainly left a lasting impression that I wanted to do something that assisted the people. He'd been a jury lawyer. He'd been a lawyer for people that were accused of criminal offenses. Like one of his famous wins, I remember always, is there was a case where a person was accused of being a murderer. And the person who was accusing him had said, well, I saw him there. I saw his face as clear as possible. It was a full moon. And Abraham Lincoln, because Abraham Lincoln was a country boy, well, he knew a lot about things pertaining to the country. And he even had reference to what a lot of people used back then and still do, the Farmer's Almanac, and was able to produce it and show that on the night in question, the witness was lying because there was no full moon. In fact, there was no moon at all. And so he couldn't have seen the person's face by the light of the full moon. And of course, he got an acquittal for his client. But that was the kind of the power of the law that left an early impression on me.
It's a very interesting and unique story. Thanks, Michael. My next question for you is, so we talked about your undergrad, that you basically played football, switched from political science to philosophy, then you went to law school in Saskatchewan. So how did you make the jump from law school in Saskatchewan to becoming a practicing barrister?
I'm sorry, the last part was perhaps a bit muffled. How did I go from the University of Saskatchewan to practicing law here in Ottawa?
Yeah, to just becoming a fully licensed barrister.
Oh, the process, sure. So the accreditation process is governed ultimately by the Law Society of Ontario, or whichever law society you happen, whichever province you happen to be in will be governed by that respective law society. Lawyers are interestingly, as far as I know, one of the few remaining professions that are self-governed. We're not governed by a government entity. We govern ourselves. And part of the reason that we have that is because we often are challenging the government. So it's thought that we are better able to discharge our duties if we're detached from the government to begin with. If we're already under the guise of the government, we don't provide necessarily the best ability to provide a detached and kind of sober analysis. So it's law societies that are independent that determine kind of the process. And I'm sorry that I don't have the exact preconditions or criteria for admissibility to being a lawyer, but at the time, off the top of my head, I believe it was you needed at least 2 years of undergrad. You didn't have to have graduated from an undergraduate degree in order to get into law school. So there was a requirement of some post-secondary, and this doesn't apply to mature students. So that's a different way to apply to become a lawyer. But generally, you need 2 years of post-secondary education at least, but generally it was some sort of post-secondary degree. Most people had an honors degree or a Bachelor of Arts. And then you obviously get into law school, you have to complete law school. Having then completed law school, you have to complete a series of qualifications. The qualifications have changed over the years, but back when I was preparing to become a lawyer, I had to complete a 12-month articling of articles of clerkship program, and that's where you work for a practicing lawyer, or you can do it for a judge, for example, and you're functionally an apprentice. You're not a lawyer at that time, and you learn the kind of the pragmatic side of things under a lawyer or a judge for a period of time. You also, during that period of time, before or after it, but certainly before becoming a lawyer, you have to write some qualification exams. So there's 2 exams that you have to pass. At the start of this whole thing, you may have heard me use that term that sounds kind of old-fashioned, a barrister. Well, you have to write your barrister's exam and you have to write your solicitor's exam. So in Ontario and in Canada, all lawyers are barristers and solicitors. We perform both roles. Perhaps I'll take a moment to explain to the listeners what that is. So it's a very antiquated set of titles and comes to us from England. We've inherited our legal system from England, who has a common law system. In the common law system, there used to be various legal professionals. So an individual who would go and get clients or meet with clients and prepare cases for court were called solicitors. They would do the solicitation work, but they weren't the people that actually went into court and argued the actual ultimate case. That was a job that was performed by people who went to the bar, or barristers. And so that was the real difference. The solicitor kind of does the behind the scenes, the office work, and then they pass over the file when it's ready to be argued in court to the person who goes to the bar, the barrister. So the barrister and the solicitor. And I mean, there's a couple of other distinctions that used to exist in England, but for our purposes, there's a barrister and there's a solicitor. And in Ontario, all lawyers are barristers and solicitors. So in order to be called to the bar, you have to pass both exams. A barrister's exam, a solicitor's exam. At the time, I believe each exam was 7 hours each, and several hundred multiple choice questions. If memory serves correctly, I mean, we're going back about 12 years at this point in time, but that's the qualification process. And so once you pass your exams and you complete your articles of clerkship and you've completed your undergraduate degree or the requisite criteria, you could then get called to the bar, and you have to go through a formal process. And our job is a job that you can only do if you swear an oath. So you get sworn into this job. And not only do I serve clients and the people, I also serve the court. I am an officer of the court. So those are some of, I think actually all of the criteria in terms of when I completed my articles of clerkship and ultimately got called to the bar. That's kind of the process that I had to go through. Perhaps I'm not recalling a form here or there, but that's really the major broad brushstrokes.
No, that's okay. That's everything we need anyway. Thank you for explaining it in so much detail. And if you forgot 1 or 2 forms, I think that's okay. I wanted to ask you, and you alluded to this earlier in our conversation, the fact that you don't like the term criminal defense lawyer because it has the word criminal in it already, kind of portraying the bias that the person is guilty. So I really like that you mentioned that. So in addition to that, are there other aspects of this field that you potentially dislike?
Oh, very, very much so, because the law as it exists should be majestic. right? These things like the presumption of innocence, this notion of proof beyond a reasonable doubt. We're supposed to have a system of justice that prefers to acquit 10 guilty people than risk convicting one innocent person. We're supposed to be very open-minded. We're supposed to be very slow to judgment and only make decisions if we really unquestionably, objectively have the proof. But oftentimes the pressures of social situations will cause us to take shortcuts. People start saying, oh, well, that's just a technicality, Mr. Johnston. We don't really need that law. You know, we all know what really happened. And so for me, that's something that sometimes I can find difficult. And perhaps it's simply my perception, but I believe the law as it has been written and the law as it's guaranteed in the Constitution is a majestic edifice. But we find all types of ways to tear down the walls improperly most times because we want a result. And the procedure that exists to protect us all stands in the way. So sometimes it's society that cuts corners in order to get where they really want. And I guess that troubles me. I see, for example, politicians all the time coming along and changing the law if a case gets won and they don't think that case should be won. Well, they don't appeal it in court anymore. They just go and rewrite the rules, right? Which is pretty weird for me because, again, we have a system. Recently, there was a couple of cases that were very public. There was, for example, an acquittal that happened in the case of Gian Gameshi in a very public sexual assault trial. And they went and rewrote the rules to make it more difficult to perhaps get an acquittal. It's one of the things that it's difficult to ignore. They came along and changed the law. They didn't appeal the decision. There was also another very famous jury trial where, you know, after an acquittal, the government didn't appeal the decision. There was no legal error to appeal, but then they changed the way in which a jury has been picked for the last 1,000 years. And so sometimes when you're involved in a system that is supposed to move slowly and be a function of some stability, that's why it's called the common law. You know, previous decisions inform future decisions, and change happens, but it happens in a certain slow and regimented and somewhat principled way. But then all of a sudden you can have a politician who isn't a lawyer at all, but needs to keep their job and wants to satisfy people that are outraged, and the people themselves don't know the ins and outs of the criminal justice system. So things get passed, the system gets changed, and then the individuals that work within it have an all the more difficult time trying to discharge their duties. So I can find that very, very frustrating, if that makes sense.
No, yeah, it makes perfect sense. Do you mind describing for our viewers how a jury in Canadian society is picked, and in terms of like what types of cases need a jury anyway?
Well, I mean, so let's start here. How is a jury picked versus what kind of cases need a jury? So let me address the second point first. What kind of cases need a jury? Any case where the government can put you in prison for 5 years or more for a criminal offense, you are guaranteed the constitutional right to the benefit of trial by jury. So Section 11F of the Canadian Charter of Rights and Freedoms guarantees to individuals the benefit of trial by jury. So that's a constitutional right that was entrenched in 1982. So until they can change the Constitution, every single crime that is alleged against a person where the person will go to jail for 5 years or more is a offense that can be tried by a jury. Now, that doesn't mean that it's going to be tried by a jury, because some cases allow for you to elect to be tried by a jury, and other cases make it mandatory. So we have certain offenses in this country that we call 469 offenses, because they're offenses that are literally listed in Section 469 of the Criminal Code. Murder is an example. Murder generally must be heard by a jury. And then there's now certain exceptions in certain provinces where they'll let a judge hear that, but that's somewhat exceptional. So that's the nature of the jury requirements. Some are mandatory, some are elective. For some offenses, there's no option at all. If you get charged with a summary conviction offense, for summary conviction offenses, which is, I'm trying to think of a true summary offense. There's not many that I can think of off the top of my head, but when it's a lower level offense, they're just not going to give you the option. And many offenses are what we call hybrid offenses. So a Crown prosecutor can elect to try you by indictment, and that makes it more serious, and oftentimes may give you the right to select a jury or ask for a jury, or they can elect to proceed summarily. Summarily literally means more quickly, right? So a summary, to do something in a quick fashion. And so part of the summary is to do it without the proper procedures to avoid the trial by jury. So that's, and then it becomes somewhat relative to your lawyer, because there's some lawyers that like juries. There's some lawyers that don't like juries. There's some lawyers that are good at it and some lawyers that are bad at it. It depends on the personality type. At the end of the day, it's an interesting, I would say a fascinating institution, because it places so much responsibility on citizens. You know, citizens become responsible for themselves and their communities. But to be a jury lawyer, you do have to be able to speak to not just one judge, you have to speak to 12 total strangers. And your case is obviously informed, if you're a defense lawyer, by the presumption of innocence and proof beyond a reasonable doubt. But you're not pulling any technicalities over 12 people. You know, it's a really, to me, I love the institution, because just like we go around every couple of years and ask citizens to vote and determine who should be in Parliament and what should happen in Parliament, because that's ultimately what we're doing when we ask citizens to vote. Decide what should happen in your country, citizens. Similarly, when we turn around and we have a jury trial, we're asking the citizens of the community, what do you think should happen in your community? So for me, I'm a huge fan of this institution, and I have an immense belief in the collective good sense of people. You know, people live in the real world, and they have to make judgments that they themselves have to suffer the consequences for. So, you know, I really like juries. And that's not to say that judges aren't wonderful. There's some exceptional judges as well. But for me, it's an institution that I really come to appreciate. Now, you asked me about how juries are picked. Now, that's a very interesting and somewhat in-depth question. But generally speaking, juries are picked by two levels of government and then the lawyers. So what I mean by that is the government writes certain laws about criminal procedure, about picking a jury. Then the provinces are entitled to write laws about who can be on a jury. And so the provinces will send out certain questionnaires and ultimately compile what we call a jury roll. Okay, so that means the sheriff in any local town or municipality or metropolitan area will determine who in any 1 year can be on a jury, and that sheriff will compile a list of, let's say, 200 people as informed by legislation passed by the province. And so once there's a list of people that could potentially act as jurors, if there is a case that needs jurors, then people from that list are brought into the courtroom by panels. You know, you'll bring in panels of like 20 or 40, and you might have 200 people in a room. And once those individuals are brought into a courtroom for a particular case, if, you know, I have a case where I have selected trial by jury on a client's behalf, and we are now at trial, and the provinces have written their laws about who can serve, and the sheriff has determined that these people can serve, and those people are brought to the courtroom. Now, once in the courtroom, the judge can excuse a number of them for a number of reasons. The judge can stand by a number of those people in case you run out of jurors and they may be needed to be reached later on. And then the individuals, the lawyers, have a right to challenge jurors or potential jurors, because that's another one, a lot of people call the people who haven't yet been selected jurors. You're only a juror if you swear an oath. So you're not a juror before you get into the box. Juror actually comes from the Latin word jurare, which means to swear. So they're actually called veneermen before they become jurors. And so that's what's happening is by the time a judge has excused people and has ultimately stood some people by, and now the two parties are saying, I might want to question a couple of these veneermen because it may be that they're racist. My client's black and the victim was white, and there's a lot of racism in society. We've all taken notice of this. We want to make sure that the people that are potentially going to sit on the jury are not people that have a bias that they're not capable of setting aside, because ultimately a person should be tried on the law that was written and the evidence that's admissible in trial, not your sympathies for a certain person or your prejudice against a certain person. So once that process is properly observed, that is, the judge stands people by, the judge excuses people, the lawyers on either side exercise their challenges for cause, you need to establish a realistic potential for bias. And if that's established, then you question the jurors until you get 12. And you might get 14 if you need to take additional jurors, because sometimes people drop out during a case or whatever. But and then once you have the appropriate number that's been determined for the case, the jury is kind of put in charge of the person whose trial it is, and you're off having a trial. So that's in short how you pick a jury.
Thank you so much, Michael. We've had lots of lawyers come and do sessions like these with us, but no one's ever brought up a jury before, or how they're selected, or just a jury in general. So I thought I'd ask, because I know a lot of people would find that fascinating. So thank you for explaining that.
And I'll say this, if people are interested in that, I would say this, because this is very important. That's a generalization. And the Supreme Court of Canada recently, in a case called Regina and Chuhan, which was released earlier this year, confirmed that there are in fact some changes. We used to have a couple of different ways to challenge, and the judge is now going to be exercising their influence slightly differently. So things have changed, especially from the past 9 years where I've been practicing, but also from the past, let's say, 50 or 100 years before that. But all that's to say, if you are interested, which I am interested, and I would suggest to you it is an interesting subject, the Supreme Court of Canada's decision in Regina and Chuhan better explains where jury selection is headed, because nothing is fluid necessarily, nothing is static in the law. Everything is changing a little bit. And for whatever it might be worth, I actually had the pleasure of appearing in front of the Supreme Court of Canada on that case to argue for a certain form of jury selection.
So we're nearing the end of our session, Michael. So I'm just going to end it off with asking you just this last question. Do you have any advice that you would give to young aspiring legal professionals like myself? Perhaps something that you wish you did, or just something that you think would be beneficial for the younger generation to know?
Well, I guess a couple of things, enjoy the process. Learning, for me, looking back, was some of the funnest times of my life was honestly when I was working hard at learning my craft. Like even when I was playing football, I look back and some of the things I loved the most was just practice. We're going to the gym, we're running the drills and learning, getting ready for game day was actually just as rewarding as game day, and in fact, you spend more time preparing for it than you actually do playing it. I remember my coach saying that to me. If you don't start to love the process and you're only in it for the games, you should quit, because the games are only a small percentage. So start to appreciate and embrace the process of learning, because I think, and this is just my view, I accept that I could be wrong. I believe that one of the marks of a good legal professional is somebody who's always prepared to keep learning, to keep questioning what they know. We should really think of ourselves as kind of epistemologists, people that are in a quest for knowledge, and knowledge requires that, to always be thinking and testing it and questioning it.
Mm-hmm. So I think that's never kind of like
stay humble, like you don't know, until you know something until you go and talk to somebody else and then they show you, oh, there's this whole other area, you know.
Yeah.
So
But
I'm
I
constantly
especially like the
constantly
part-
having to reinvent what I think I know, and for me it's part of just enjoying the learning process.
Mhm. But I especially like the part where you're talking about enjoying learning the process, because I feel like I'm guilty of this myself, that a lot of us just view lawyers as the people who fight in court, but no one ever really thinks about the fun work as getting all of the papers ready and talking to the clients and stuff. And that is majority of the job. So I really like that piece of advice. Sorry for interrupting you. I just wanted to say
Hey,
that.
no, it's my pleasure. This is interactive. And then for me, and again, you're asking me, so I guess that's why I'm saying it. But to one of the things that's been really important for me in my life is history. I think that we are where we are standing on the backs of our forefathers. In some ways, some of the things they've done are terrible. But there's to think that that's the only way to look back at the past is, I think, to be a bit short-sighted, because there is some incredible things that have happened in the past. The freedom, the liberty that we now enjoy, that's like 500 years old. Right? I mean, it's only since the church really got properly divorced from the state, you know, after Martin Luther's 95 Thesis, where individuals started to like become free. I read this book once called Towards the Light of Liberty, and it said that. It said, you know, this freedom that we have now, 500 years ago, you had to be a king or like a pope or someone like that to walk around and be free like we currently are. So I've really appreciated trying to learn about the history of liberty, the history of law, and they're interrelated. For me, one of the things that I hate hearing, and I'm a stickler for words and stuff like that sometimes, and one of the things I hate the most hearing is people that will say to me, well, that's just a technicality, sir. You know, liberty is a technicality in some ways. There's a very famous US Supreme Court justice that I always quote called Justice Felix Frankfurter. He very insightfully said that the history of liberty has largely been the history of observing procedural safeguards, just observing process, right? So for me, it's been very important to learn the history of the law, to know how we got here, because we didn't get here by accident. And so many people don't appreciate the procedures that were put in place to build us up to this point. And now that we're here, people are starting to pull that out and throw it away. This is one of the things that I was arguing at the Supreme Court of Canada, for example, that the institution of trial by jury blossomed over 1,000 years, and they were trying to take out one of the early planks without any regard to how that might topple the whole edifice. History is important. Nothing, and history repeats itself. So for me, that's been important. I'm sorry if I'm being repetitive on that point, but understand how we got here. It'll give you a good sense of appreciating what we have, but also give us insight into maybe moving into a more positive future.
Thank you so much, Michael. Honestly, that is probably the most unique advice I've had from these sessions. I love your attitude and I love the advice you've been giving us. I personally really appreciate it. And I've had a fun time chatting with you today.
Well, it's been my pleasure.
Mhm.
Thank you so much for asking me to come and talk a little bit about my experiences and truly what is my passion. You know, I've been very blessed to realize on what was my childhood dream. And, you know, I get to help people all the time. I don't look at people like criminals, and I ain't no criminal defense lawyer. I'm a lawyer who helps people with their rights. And that could be your brother, it could be your sister, you know, anybody could be accused of a crime. That's the thing to remember.
Mhm. And also the Constitution is one of my favorite things to study in law as well. So we also have that in common.
Oh, very cool.
Yeah. I'm just going to go ahead and end the session. Thanks again, Michael. And thank you to everybody who's tuning in. Have a good night.
My pleasure.